Okay, now we're live. There we go.
Okay, let's try again because we started talking already.
Hi, everyone. Welcome to another episode of Positively Family Law. Today, we are going to talk about alimony, which I think is a very big thing that people, kind of associate when it comes to divorce, that and child support. So we've already talked a little bit about child support, so we figured we would talk a little bit about alimony and how it could play or not play into your divorce and decision of your situation. So, Heather, why don't you give us a little bit of an overview in regards to what alimony is?
So the most broad way to describe it would be the support that one spouse pays to the other spouse for, basically to not, I don't want to say equalize the income between them, but help the spouse who generally makes less money be able to continue providing for themselves once the marriage is over. So that's probably the easiest way to think about it.
Gotcha.
It's like child support, but for adults.
Okay, perfect. That's the best way to put it, I think. So there are different types of alimony, correct?
There are. But there's also, before we even get into what types there are, because everybody wants to know, is alimony an issue in my case? For the most part, alimony is always an issue that needs to be decided, even if it's just being waived. It usually needs to be dealt with within a divorce situation. It's only applicable to a divorce situation. So if it's an unmarried couple and they've been living together and then they split up, that's not an alimony case. You have to have been married to be able to be eligible for alimony. Within that, there's not an automatic assumption that somebody gets alimony. There still has to be the ability for the person who would be paying alimony to pay the amount, and there has to be need by the person who would be receiving it. But yes, there are, once you get past that initial equation, there are a number of different types of alimony.
Okay. So what are they?
So the biggest one is just coined general alimony. Surprise, surprise. So that's basically your catch-all phrase. That's the way it's typically calculated, and this changed a little bit when the tax structure changed. So it used to be, and we'll go back to that, it used to be that if a person was paying alimony, they got to write that amount off their taxes, and the person who was receiving alimony would have to claim that as income and would have to pay taxes on it. The tax code changed, and now you are no longer able to write off the amount that you pay for alimony. So it used to be the assumption that between 30 to 35% of the difference within your incomes. So just for ease of numbers, let's say the higher earning spouse earns $200,000 and the lower earning spouse earns $50,000. The difference between that is $150,000. So you would typically take somewhere between 30 to 35% of that difference, and that would be the alimony payment broken up on either a weekly or a monthly basis. There's always reasons why it should be higher or lower, but that was typically the calculation that was used. Now that the tax code changed, that percentage is also changed, and a lot of that comes down to what judge you end up in front of. So I've seen anything, and the higher the income, typically, the smaller the percentage. But I've seen everything from 10% to 33%. So it really depends, but they're giving people, they're giving the person who's paying alimony a credit, basically, and decreasing the amount of alimony being awarded to make up for the fact that they don't get to write it off the taxes any longer. So that's kind of like the main alimony type. The other types, there's something called rehabilitative alimony, and that's applicable for any marriage. You can get it on top of general alimony. I haven't seen that very often. Or you might get, instead of naming it general alimony, it might be just called rehabilitative alimony for a shorter period of time. And that's basically, a time set payment that allows that person to maybe enter the job field or go back to school. It's a period of time that they'd receive that extra support so that they can get their own income going. And you see that a lot when somebody's been out of the workforce because they've been a stay-at-home parent, whether it's mom or dad. That's typically when you'd see it. Or if somebody for some reason had not been able to work for a long period of time, maybe due to an injury, if they were able to enter back into the workforce and just needed additional training, that's typically when you'd see that type of alimony awarded. Then there's two types of alimony that you can only get if your marriage is shorter than 5 years. So for all those people who have a short-term marriage and they're like, can I get anything out of this? The question is maybe, but the two types of alimony that really come into play here. First is reimbursement alimony. And generally in a shorter term marriage, which a 5-year or less marriage is considered short term, it might feel like eternity, but it's not. And so the idea is to get both parties to leave the marriage very similar to the same condition that they came in. So what you see sometimes is people get married and then one person will work really hard and pay for the other person to go to school. Now, the reason they've done that is to invest in the marriage, invest in their future, so that the other person can get a better job and start bringing more money into the family. What happens in those types of cases is this is where reimbursement alimony comes in. You know, if you spent $50,000 to help put your spouse through school and then you divorce, you're not getting the benefit of your investment. So you can basically look for them to reimburse you for the money that you paid to help them advance to where they are. Then there's also a type called transitional alimony. And this is kind of the same thing. You know, it's a very temporary type of support. Again, less for, applicable in marriages that are less than 5 years. And it's really to help the person adjust to their new life, because now they're not together, they're separate. And maybe it's just getting an apartment, getting a car, getting themselves back on their feet. So that's a different type of alimony. So depending on the length of the marriage and what's going on, there might be, you can sometimes go after more than one type. So, but don't get too greedy because judges don't like that.
Yes, that's true. So now it's not a situation where every divorce can get alimony, correct? It's situational.
It is situational. And typically if the two parties who are getting a divorce, if they cumulatively earn less than $250,000 a year, so how that's made up, to be determined. But if there's children involved and they earn less than $250,000 combined, that $250,000 is typically going to go into a child support calculation. So there's this idea, more than just an idea, but it's basically you can't double dip with money. You can't go, let's say parent A earns $150,000 per year. You can't say that I want to use that $150,000 to get child support and then turn around and say, and I want alimony on top of that, because there's only so much money to go around. So if it's going towards child support, typically there's not going to be an alimony payment unless the incomes are very disparate. And in that case, it might be, some sort of unallocated support. And those are all things that are negotiable. But typically you'll just see a child support payment. Anything above 250, that's where the world's your oyster. You might get some child support, you might get alimony. Again, you might get some combined figure. It might be, there's so many different things. There's no black and white in those types of scenarios.
Gotcha. Okay. So one thing that I think also plays into alimony, at least from what I've seen in the past, is prenuptial agreements. So, if you have it in your prenuptial agreement that you waive alimony, that can't really be undone, right?
Yes and no. There's some really poorly written prenups. So, if you were out for dinner before you got married and you said, oh crap, like I don't want you to get alimony from me, and you guys write on a piece of paper or on a napkin that, we both waive alimony, neither one of us will pay each other alimony if we get a divorce. Well, that's not going to be upheld, and even if it's a situation where it's a very good agreement, if the situation changes so much by the time of the divorce, let's say you've entered into a prenup, but 25 years has gone by, and let's say one person, became disabled, that might be a situation that a judge would say, you might have agreed to it, but we're not going to uphold it because that wouldn't be fair. This person would pretty much be left out on the street. There's other reasons why they might not be left on the street that you could argue, but that might be a situation where a prenup wouldn't be held up. But typically, if there is a very, very clear waiver that shows that you understood the rights that you had moving into the marriage in regard to alimony, that you are voluntarily waiving that right, that you believed and you can support yourself, typically that would be upheld and it should eliminate that argument. So if there's a question, and you're getting married, get a prenup, because it's better to have one than to not have one and then have to fight about it later.
Of course. So another question in regards to that, let's say you get divorced and, in your divorce decree, you say, that there's no alimony. Can you modify that later, or is that kind of a done deal once the divorce is finalized?
As with many legal responses, I'm going to go with that as it depends. There's different types of waivers. If I'm married for 10, let's say 20 years. Mm-hmm. Yeah, let's say 20 years. And I waive past and current alimony, but I don't waive future alimony, I can eventually come back and get it. And that really goes, it doesn't necessarily have to be 20 years. I don't know. That's why I was thinking, like, why am I using this figure? There's no rhyme or reason to the 20 years. But if you waive past and present, but you reserve future, then you can go after it in the future. You can ask to modify it. Now, you also, to enable yourself to be able to modify it, you need to put language in the agreement that basically allows it to be modified. And the language that people want to look for, and a lot of time judges will ask about it, so pay attention here, but it's called survival or merger. And if something survives a judgment of divorce, that means you cannot modify it. It's non-modifiable. If it merges, think merger modifiable. So if it merges with the divorce agreement, you can go back in and change it. So you really want to pay attention to that language, because it's one of the things that if somebody comes in saying, I want to change something, we immediately go look for the survival and merger language, because that will dictate whether or not they can even get back into court to do so.
Gotcha. So I'm learning that language is very important.
Language, even though it sounds like, I get it. When people read it, they're like, the legal mumbo jumbo. It is, but there's reasons for it. And if you don't have the right legal mumbo jumbo, you can really screw yourself over later.
Exactly. Well, I think we are going to do like a whole episode just on like legal jargon in terms of how important it is that like this one word can make or break like an agreement, because it's so important, especially in law, especially in family law.
Well, it's not even just the one word. It's sometimes how a sentence is structured and how clear something is, in order to find somebody in contempt. And I know this is, veering off of the alimony issue that we're supposed to be talking about. But if somebody wants to file a contempt, one of the things that the judge looks for is it a clear order? And so if it's not a clear order, that person cannot be held in contempt. So we've had people call us and be like, they're not following this. And we look at it and we're like, well, we don't even really know what it says. So how is a judge ever going to hold them accountable? So not just the words, but the structure of the sentences, there's kind of a lot that goes into it. That's why we do what we do.
How long can alimony typically go for? Is it for a lifetime? Is it for a certain amount of time? Does that depend on the length of the marriage as well?
So it used to be that you could get a lifetime alimony award, and it would just go on forever until somebody could bring it back into court and say that, there's a reason for it to end, or if it survived, you weren't getting out of it. So, but then there was what was called an alimony reform that took place that basically put limits on alimony. So now it really goes by the time period that you're married. And For this, I'm talking specifically about general alimony. So if you were married 5 years, it's a smaller percentage. If you were married 10 years, so it basically increases in 5-year increments. And this is why it's really important when people call in, we're like, when did you get married? When did you start living together? Those are the things we're looking at, because it might be really important to either, if we're going to be representing the person who it might be liable to pay alimony, we might want to file as quickly as possible to get the other side served so that we stop that alimony clock. If we're representing the person who more than likely would be receiving the alimony and it's really close to the next jump, we might say, we might want to hold off for a couple months so that we can ease up past that line so we can get the longer duration of alimony. Once you hit 20 years, that's kind of where it caps off. You're eligible to get up to 80% of that 20 years. Mm-hmm. Even with that, so if you've been married for 20 years, more than likely you're a little bit on the older side. And I say that, you know, having somebody that got married at the age of 21, so my 20 years would have been already have taken place, but I got divorced beforehand, and I don't think I'm really old. So for not everybody, it's applicable, but a lot of times when you see the 20+ year marriages, they're getting closer to retirement age when they're getting their divorce. And the alimony reform also cut off alimony at retirement age, and not when you decide you want to retire, because some people retire at 45, some people retire at 50. You don't get out of paying alimony just because you retire early. It's the age of Social Security, which I believe is either 67.5 or 68. I forget which one. So alimony can go pretty much up to there. And then there has to be a really good reason to continue with it. And a judge would have to basically find an exception to that duration. So there's not really, unless you enter into some sort of agreement that provides a surviving agreement, lifetime alimony, you're not going to find that anymore. There's going to be some sort of cutoff. Or if, you know, somebody dies, obviously, then it gets cut off. A lot of times, if one person gets remarried, or even if there is, you know, a cohabitation for a period more than 3 months, that can either decrease or terminate alimony as well.
Okay, leading into that, I was actually just going to ask. So I'm going to put forth a scenario for you. So let's say,
okay. Hold on, let me pay attention. Do I need to take notes?
It shouldn't be that complicated, I don't think. So let's say you have a couple where one spouse was the stay-at-home person and took care of the family, took care of the household and the kids, the whole marriage. Like they never worked because they never had to. Let's say the other spouse did all of the work and everything like that, made all the money for the family. They get divorced and the spouse who's been at home gets alimony. What happens when that said person, I know you mentioned like getting remarried. So like if they get remarried, what happens? And then 2, what happens if that person gets like a really, really good job and they are like now making kind of equal to the other spouse, or, you know, if not more than the other spouse? What happens?
Yeah. So both of those are good questions. And for both of them, I'm going to assume that if there were kids that they were raising, they're grown up and no longer eligible for child support, because that complicates it a little bit. But so if we're assuming there's no kids and no child support in those particular situations, if the person who's receiving alimony gets remarried, that's usually a trigger that will end the alimony. If they just start living with somebody, it might trigger it to be over, or it might trigger the ability to decrease the alimony based on the theory that the person that they're living with, and it doesn't necessarily have to be somebody you're in a relationship with. It might be a family member or, you know, a roommate. If they are somehow decreasing your expenses to the point that you don't need the same level of alimony you were getting before, that can, present the basis of the modification for a change in circumstances. Now, if it's a situation where, let's say I like to use us, we get married and then we get divorced. So let's say you're the high earning spouse and I never worked, and then we get a divorce, and then I'm bored one day, so I play Keno at the bar and I win, $1 million. And that's way more money than we ever had. With us being divorced, and the standard of living was not one where you were used to that $1 million, you probably couldn't come after me, but you could definitely file something to say, look, she doesn't need alimony anymore. She just won the megabucks, or Keno, she's doing way better than I am. So that would prevent or supply the modification to allow for the change of circumstances to terminate the alimony. So a lot of it really is just situational based.
Gotcha. And the other thing is, it is on, it is your responsibility to file a modification. Like, it's not just.
Yes. Yeah. If you have the obligation, and there's not a triggering event that's very clear within your agreement. Like, you can't just not pay because you believe your spouse moved in with their significant other. You'd have to go to court, because if you don't get a new order that either terminates it or decreases it, that other person can file a contempt, and then you could find yourselves in a big old pile of hot water with a judge because you decided to play judge and didn't get the court's approval. The other thing that I think is important, and I know we have like 5 minutes left, so I'll try to rush through it. A lot of people think, because of the fact that if they have kids and they're not over the 250,000, a lot of times they think, well, it's not a big deal if I waive alimony, which is true to a point. And although most people don't like to think about it, part of an attorney's job is always thinking about what's the worst case scenario. So let's say it's me and you, and you've got kids and I'm the paying spouse. So we've got, Jack and Jill, and you guys and I'm paying you child support, so there's no alimony. Mm-hmm. If you waived alimony and you get in a car accident or something terrible happens where Jack and Jill die, then you can't come after me. Child support's going to end because they're no longer there, so they don't need the support. You can't come after me for alimony if you need it. Whereas if you reserved your right for future alimony in that worst case scenario, which I always say, I really hope it never happens, but you always have to think and protect yourself in case it does. If that were to happen and you lost that child support, you could still turn around and come back for alimony if you reserved your right and you merged that language.
Yeah. All comes back to the language.
All comes back to the language. Language is important.
Yes. So we're going to talk about that next week. All over language. Okay. So anything else that's important, obviously, and I think it's the same with child support in terms of like filing the modification. Like, if you have a change of circumstance, you have to get something in court. Otherwise it's gonna bite you in the butt otherwise. Mm-hmm. So, just be conscious of that, especially, with alimony or child support. I know it's not the same, but, keep that in mind. And then if you have questions about, kind of where you fall under this kind of, I think it's like a graph in terms of the different levels of alimony and kind of what qualifies what. Your best bet would be to talk to an attorney, kind of go through the length of your marriage, kind of your assets and kind of the income difference between the two of you. Speak to an attorney about that for sure, because that's the best way you're going to know kind of what your options are in terms of what types of alimony, and, kind of maybe run some rough numbers in terms of what you could be looking at. Mm-hmm. So, and we do offer consultations, so call our office and our attorneys can help you.
You'll speak with Kayla. She's fantastic.
Gather all the information, and then an attorney can definitely walk you through all of that, because, there's a lot, like we discussed today, there's a lot of things that go into the decision of alimony. So,
yeah, and generally within, if somebody's calling in regard to a modification, we usually recommend that they should jump on the phone with an attorney. We charge for an attorney consult, but a lot of times the investment that you make for that 1 hour, the attorney can look at the language of your agreement, can listen to what's going on in your case, what the financial situation is, and give you really an overview of what, number one, whether you can even file a case. And we've had this both with alimony and people that come in to modify their child support. We've had people come in and they're like, I want to change everything. And we sit down and we walk through everything. And we're like, if you try to change anything right now, it's not going to be a good result for you, because for one reason or another, like either you're making way more money than you were, like just the passage of time doesn't necessarily remove the ability to pay. So, it might be detrimental to you in some ways to file a modification. So those are things that, the investment of the 1 hour can really pay off, rather than just hiring an attorney, going in, spending a lot of money to not get a result. And that's one of the things that I really pride our firm on, or pride myself on with our firm, is we will tell you if you don't have a case. We will tell you if we don't think your case is good or it's putting you at a lot of risk, because we do like to get good results for our clients. And, if we take on a case that we really question whether or not we can get a good result, it's not going to be a good look for us. So we do tell people when we don't think they have one. And that's where, the investment of that 1 hour can sometimes be a lot.
Yeah. I mean, it's the price difference, honestly, too. Like when you're paying for a consult compared to, if you just go and drop thousands of dollars on a retainer and then you go in front of the judge and you're like, you don't have a case here. Like that. And even, especially if you're doing it yourself too, like you do all this work and you try to do all of this stuff to get it. And then you end up like walking out paying more money, or, ending up screwing yourself, and you don't want to do that. So, I do tell people all the time that we don't BS you here at this firm. We're not gonna,
we don't
trying to take your money. We want you to be successful because that makes us successful. So,
well, don't get us wrong. I mean, we like to take your money. We just like to actually produce a result for it.
I mean, though, like, taking, helping you through that situation, it definitely, we don't want to put our foot in our mouth, and we don't want you to end up in a worse situation than when you came to us. Our job is to make your life easier. Yes, it costs money to do that, but we're going to be honest with you through and through, not just the consults. Even if you're a client, we're going to be honest with you.
You're honest with you until you become a client. Just kidding. No, I think that's where people really appreciate us. We've told our clients that, you're acting unreasonable. You're really, acting off of emotions. And I think they appreciate that because it gives them a reality check as well. Because for us, it's all about the cost benefit analysis. What are you paying for what you're going to get, and is it worth it if you get your best case, but is it also worth it if you don't get your best case and you get your worst case? And so we constantly do those types of analysis. And especially when you're dealing with alimony, which is not a black and white issue, it's just not. There's a lot of factors that are involved there. So it's one of those things that we're always talking about, what is it worth, not just on a financial level, but on an emotional level, because going to court is draining. It's hard. And so that means something just as much as, the dollars coming out of the wallet, because if you're not sleeping at night, if you're stressed, those are all things that play into your general health. And we take all of that into consideration here.
Exactly. We not only want to get you a good outcome, we want you to be a better person through the end.
Exactly.
That is our goal. So I think that's definitely what sets us apart, which is good.
I think so.
Awesome. Well, very informative. So if you have any questions about alimony, if you're looking into getting it, if you think you may be qualified for it, if you're questioning the wordage of your current divorce agreement, call us. We can do a consultation and you can speak to one of our amazing attorneys and they can go through all of that with you. And
sorry, one more thing. And this is even important if mediation is great. If you're able to come up with agreements on your own, that's wonderful. But if you're using a mediator and you don't have an attorney on your own side, you may want to have hire an attorney to just review the agreement and make sure none of the language was missed. So that's definitely something, especially again, in regards to the alimony. There's good mediators, there's bad mediators, just like there's good and bad everything. But it's always good to have a second set of eyes kind of review it before it goes into court and becomes the document that you must live by.
Yes. Like we talked about last time, even if you're doing things on your own or whatever, it is always beneficial to have an attorney review things for you because they know the language. I mean, I work in this environment and I don't even understand half the language. So imagine someone who's dealing with all the emotions and stress to try and figure out how to put this thing together. And even if you are using a mediator, just having someone who that you are paying to look out for your best interests is always beneficial, no matter what. So definitely do that. And we do that here at the firm. You know, if you're looking for someone to just review an agreement, even though you're using a mediator, we can do that. We can definitely do that.
Okay, wonderful. All right. Well, I hope everybody has a great weekend because it's finally Friday. I've picked up golf, so I'm going to go to a golf lesson tonight as long as it doesn't rain. So I'm excited about that. So is it sunny?
It's going to rain all weekend.
Well, I just need to get through like 8 o'clock. So
Enjoy the long weekend, and
that's great. That too.
Yes, it's Memorial Day.
I don't know. I just work.
And relax. And we will be back next week with another episode.
All right, great. Thank you, everybody. Thanks for watching.